from Sumner County. I represent the appellants. I would respectfully request 3 minutes rebuttal time.
All right, sir.
Your Honors, I'm going to jump right into issue number 2 in my brief that we're claiming the trial court, the Sumner County Circuit Court, erred in awarding the plaintiffs, appellees, anything over $50,000 because that's all the appellees requested in their complaint and addendum clause. This is a suit for breach of a promissory note. And that's our primary issue is issue number 2. And so I would like to focus primarily on that. Appellee argues in their brief that this should be considered under a Rule 60 standard, and I would respectfully submit that that is wrong. I don't blame the appellee counsel for arguing that in their brief. I would have done the same thing, but I have to respectfully submit that they were wrong because it's kind of it's a procedural quagmire of sorts how we got to the second amended order that was entered by the trial court, and that's what we appealed from. That was entered on October 11, 2022, the second amended order, and we appealed filed a notice of appeal 6 days later. So it shouldn't be. A Rule 60 motion was filed by my clients. They had another attorney at the time, but it should be, issue number 2 should be reviewed under a de novo standard. It's in question of law. But even if the court does look at it under an abuse of discretion standard, which is what they would do under a Rule 60, we would still submit that the trial court erred. Even if it is under an abuse of discretion standard, this court should not just rubber stamp, not saying the court would, what the trial court does. Because the court was still wrong, because like I said a minute ago, the plaintiffs only sued for $50,000, and the complaint clearly says, including breach of contract, pre-judgment and post-judgment interest, attorney fees, and costs. The appellee in their brief gives a definition of what include is. I looked it up recently, and under Merriam-Webster's dictionary, the word include means to take in or comprise as part of a whole or group. And using just common language, an example of this would be if you book a hotel room, it says the price includes one night and breakfast. It doesn't mean, and if you take it as the appellee argues in their brief, that could be expanded to include 2 nights, 2 breakfasts. That would help certainly that interpretation would help the person staying at the hotel. I don't think the innkeeper, I guess as it used to be called, of the hotel, would appreciate that interpretation of the word include. So the plaintiffs were free to draft the complaint however they wanted. They're bound by however they chose to draft the complaint. They never sought to increase the addendum clause, what they were asking for. Even before the close of proof at the trial, they could have asked the court to increase the amount of damages, but they elected not to. In preparing for today's argument, I came across a case, and I brought extras. I don't know how the court wants me to submit it. I could probably just email it to the clerk after today to give it to the court, however the court prefers. It's the case of Cross versus City of Morristown. It's a 1996 case, 1996 Tennessee Appeals Lexus 677. And it clearly states a judgment that exceeds the addendum clause is invalid. And that cites to Tennessee Rule of Civil Procedure 15.02. So we would submit that the trial court erred and that the judgment, which would exceeded $50,000, be amended to only include $50,000. But if, moving on to issue number 3, the trial court awarded attorney fees to the plaintiffs in excess of the $50,000. And if the court agrees with my client's position that $50,000 should be the maximum judgment, this issue will be pre-termitted and the court won't have to address it because $50,000 is the amount of compensatory damages that they've sought. But if the court does not agree with my client's position, we would submit that the trial court erred in awarding the amount of attorney fees it did, and it awarded $16,666 in attorney fees. And based upon the record, the court based that on the plaintiffs and their counsel's contract that provides for a contingency fee, 1/3 of recovery, and 1/3 of the $50,000 is $16,666. The court never found that that was reasonable. It just said, that contract was attached to the judgment. The trial court never said that this is a reasonable amount, and there was no affidavit submitted. The best practice, and what I've always done is, if I'm requesting fees, is submit an affidavit and set forth my time and my hourly rate, and it would show to the court and be part of the record to show this is a reasonable amount of fees. This is the time I put into it. And if an opposing party objects to that, they can certainly voice an objection, and then the court at that point could have a hearing and consider the factors contained in Supreme Court Rule 8, Rules of Professional Conduct 1.5a, which is outlined in my brief, and what it gives guidance to courts in determining what's a reasonable amount of fees.
Did your client object to any of this at the trial level?
He did not. He was representing himself pro se at the trial, and he did not participate much in the trial, and then an order was entered.
What's your position on waiver here? Obviously, you disagree it applies, but why? If this is much akin to a default judgment, isn't it? Except that your client was there and had the opportunity to object.
He did, and obviously I wasn't there. I can't speak to that, but
no, I'm just talking about it as a matter of law. Can your client waive this by not objecting?
He appeared, and so he didn't. And there was, I have to look through. There was an answer. He had an attorney at one point. There was an answer filed, and he appeared, and the court made its finding. And, I don't know at that point when he could voice an objection to this in his answer.
When were the attorney's fees awarded?
The attorney's fees, all I can speak to is what's in the record. There was not a court reporter present, and we're limited to the statement of evidence. And so all I can say is that there was a hearing, and then afterwards a judgment was submitted. I don't know if the court made the oral findings of attorney fees, and at what point my client was obligated to object. But the issue, again, may be pre-termitted if it's limited to $50,000. But
is there some reason waiver would not apply here?
It would be if you're speaking strictly in attorney fees.
Well, I'm talking about generally everything. You've got a client who, from my review of the statement of evidence, your client showed up, offered no evidence, questions no one, just was present, I guess, right, would be the best way to describe it, and didn't do anything to protect his or the partnership's interest.
I can't disagree with that based on what's in the record. I would say that he waived everything except anything over the $50,000, because that's all they asked for. And so we're not objecting to the $50,000, but a waiver of other issues. He appeared. He did not cross-examine. An answer was filed on his behalf. So whether that constitutes a waiver, I can't say. I would say that he did not waive his objection to the attorney fees.
Was there a motion to alter or amend the judgment?
That's and Judge, the procedural, the procedure of this is very confusing. There was the original judgment entered on September 1st of 2020, and then my client on October 13, 2020, filed a Rule 60 motion, had a different counsel at the time. And the trial court thereafter, a year and a half later, entered an amended order. And then the plaintiff, appellee, filed a motion to alter amend that. And then the court entered a second amended order in October of 2022, which was similar to the original order. But to answer, the Rule 60 motion only really raised the issue of that an award shouldn't have been over $50,000. And then, but it's our position that my client appealed, the time started over, my client appealed the second amended order.
I'm a little confused in your response to Judge Goldman. The motion to alter or amend specifically raised the limitation about 50,000 by a previous counsel.
It was actually a Rule 60 because it was filed over 30 days from the original order, but it did state that it was void because it's over 50,000.
Okay.
But in all candor, it didn't say anything about the attorney fee issues. But it's our position it started with.
Then some judgment was entered that needed to be amended, correct?
Correct. There was a judgment that was completely in my client's favor.
Right.
And then they filed a motion to alter amend, then the court set it a second amended order.
And what was the basis of the original Rule 60 motion?
The primary basis was that it is anything over the 50,000 is void because that's all the plaintiffs prayed for. That's primary. That's the gist of it. Is the rule? And I'll submit that it's still a void. Anything over and above that is void. So I may eat into some of my rebuttal time. I don't want to miss this with the court's permission. The court also entered a judgment for prejudgment interest in a hefty amount. And the court we submit that the court erred in calculating the prejudgment interest because the court calculated at 10% back to November 1st of 2018, the date of maturity of the note, and it based the prejudgment interest including attorney fees. If any, at the worst, it should be based just on the $50,000 because the purpose of awarding prejudgment interest is to fully compensate a plaintiff for the loss of use of funds, and we would submit that the attorney fees, they were not out attorney fees because it was on a contingency fee basis. Maybe the court can fix that on appeal or remand if necessary. Unless the court has any questions.
Thank you.
Good afternoon, and may it please the court. My name is Aaron Armstrong, and I represent the appellees, Roger and June Fulmer. The appellants raised 4 issues in their brief. However, 3 of the issues were never raised at the trial court level, so the appellees would ask this honorable court to deem those issues as waived. The only issue properly before this court concerns whether the trial court erred in awarding a judgment in excess of $50,000. The appellees are unsure why the appellants contend that $50,000 was all that was requested in the demand for damages, as appellants provided at best a skeletal argument for their position in their brief. But to the best that appellees can tell, the appellants interpret the demand in a way that all of the words after including specify what comprises the $50,000 demand. This would not make any logical sense when considering that $50,000 was the remaining amount owed to the appellees, which would render the inclusion of attorney's fees, prejudgment interest, and post-judgment interest completely meaningless. The common sense interpretation of the demand for damages is that the word including is used in a manner that is synonymous with in addition to. For instance, the demand for damages could easily be read as plaintiffs respectfully request that judgment be entered against the defendants for monetary damages of $50,000 in addition to all damages and losses incurred by plaintiffs as a result of the defendant's breach of contract with the plaintiffs, unjust or unjust enrichment damages, so on and so forth.
I'm sorry, is that the language in the complaint?
That is not-
It says 50,000, and in addition to that amount, these other items. Does it say that?
It doesn't specifically say that, but a substitution of that has the same meaning of in addition to. So it doesn't specifically say in addition to.
So you say including can mean in
It's used
addition to?
It's used synonymously with in addition to.
Really?
Or and. Yes, yes, Your
Okay.
Honor. And I cited Black's Law
Well,
Dictionary.
let me ask you about the note. Is there a provision for attorney fees in the note?
Yes, there is.
And does it say that you get an attorney fee of 1/3, or does it say reasonable attorney fees?
I believe it's reasonable attorney fees. It doesn't specify 1/3.
So how did you get to the 1/3 of the 50?
I was not present at the trial, so I'm not sure how it arrived at that.
Oh, okay.
In any event, it was waived, so it,
Well,
not trying to
maybe
be
it was
facetious
waived.
here, but it doesn't really matter what my opinion.
Maybe
of
it was
is.
waived, maybe it wasn't.
Maybe it wasn't, and that would be a determination for the court.
Don't you, I mean, normally if the trial court is requested to set attorney's fees, the trial court, there's a procedure that the rules of professional responsibility give us on setting attorney's fees when they're requested. That's normally the way it's done. You have any idea? Statement of evidence doesn't say how the attorney's fees were arrived at. It just sets a number.
Correct, and I couldn't give you specifics on how they arrived at that number. I'm just aware of the amount that was awarded.
You're aware of the request that was made, I'm assuming.
That there was a request made? Yeah.
And did the request, as opposing counsel suggested, was it a percentage request?
I'm not sure on the specifics of the percentage.
Is that in the record, do you know?
Not, there wasn't a court reporter, and the attorney that was on the trial, he's no longer at our firm, so I'm not exactly sure if that was.
I don't think I'm making myself clear. When a request for attorney's fees was a request made, for instance, a percentage of the amount recovered, or how was that submitted to the court? Are
I'm not
you aware of that?
I'm not aware.
Okay.
So the appellees would, in any event, the appellees would contend that the trial court certainly did not err in its award of damages in terms of the amount that was made. And then, so to address the other issue, well, the other three issues, the first issue raised by appellants concerns whether the trial court erred in making the judgment against the Silvermans individually. Appellees contend this issue was never raised at the trial court level and that it should be waived. But in any event, Tennessee Code annotated section 61-1307B and 61-1306A make it clear that it was appropriate to enter judgment against the Silvermans in their individual capacity. The appellants cite one case as support for their position on this issue. However, that case was not on point. In that case, the defendant was not involved in a partnership. Rather, he was the president of a duly organized corporation. The liabilities that are imposed on general partners are quite different than those that are imposed on a president of a corporation. So for those reasons, the appellees submit that it was appropriate to enter judgment against the Silvermans in their individual capacities. As to issue number 3, appellant's third issue concerns whether the trial court erred in its award of the appellee's attorney fees. As previously mentioned, the appellees would submit that this has been waived since it was never presented at the level. But in any event, opinions from the Supreme Court and from the Court of Appeals make it clear that if a party believes the trial court erred in its award of attorney's fees, then it is incumbent on that party to pursue the correction of the alleged error in the trial court by insisting upon a hearing, or to convince the appellate courts that the party was denied an opportunity due to no fault of his own. Well, the appellates never attempted to correct this alleged error at the trial court level. They cannot claim that they were denied an opportunity when they never attempted to do so. The trial court was certainly capable of adjudging the value of the attorney's fees as it oversaw the proceedings below. So appellees would submit that the trial court made a correct decision in its award of attorney fees. And then as to issue number 4, which is the final issue that was raised by the appellants, that concerns whether the trial court erred in its award of prejudgment interest. Probably beginning to sound like a broken record, but once again, appellees have the position that this should be waived as it was not presented at the trial court level. And the well-settled case law on this exact issue establishes that if a matter never becomes an issue in the trial court, opposing counsel does not have an opportunity to make a countervailing argument, and the trial court is denied the opportunity to exercise its discretion based on a full consideration of the competing arguments. There could be no abuse of discretion when the trial court is never given a chance to decide between the competing arguments. The trial court was never even given an opportunity to abuse its discretion. Appellees submit that this issue has been waived. And then in addressing the submitted amended order of judgment that was initially granted by the trial court, so the trial court actually denied the appellant's motion for relief from judgment at the hearing, and for whatever reason, they submitted a competing amended order of judgment. The trial court mistakenly signed it. That's why the appellees filed a motion to alter or amend, and the trial court granted it and signed the correct order. So that kind of clarifies, I guess, the issue with that. That's what happened, is that the trial court signed the wrong order, had a motion for reconsideration. They realized that, and then they signed the correct order. So that's what occurred at the trial court level pertaining to that issue. In any event, unless the court has any other questions, I would concede the rest of my time.
See none. Thank you. I believe you have 3 minutes.
Okay. I don't think I'll take it all up, but just to answer the court's question, the original order that was entered in September of 2020 made reference, awarded the amount of fees of the $16,666 and made reference to attached Exhibit 1, and Exhibit 1 is the contingency fee agreement between plaintiff's counsel and the plaintiff that provided for 1/3 of the gross amount of the judgment. And then the later amended order of judgment entered almost 2 years, or over 2 years later, referenced by counsel, again awards the same amount of attorney fees, but does not make any reference to the contingency fee agreement. So that should clarify that, and unless your honors have any further questions, I'm done with my argument.
The original order became final, so it was necessary to file a Rule 60 motion.
The Rule 60 was filed over 30 days from the entry of the judgment.
And the basis for the entry of the Rule 60 motion was?
Primarily, it's a lengthy argument, but primarily is that the judgment over $50,000 is void. Anything over $50,000, what the plaintiffs prayed for in their complaint, is void.
Okay.
Thank you, Your Honors.
Thank you. Counsel, we appreciate your argument. We appreciate your brief. We will take this matter under advisement and attempt to